Again, everyone, welcome back. Joining us now is Mr. Jordan Schwartz, partner in the Labor and Employment Practice Group for the Conn Maciel law firm. Jordan is our go-to person for the Americans with Disabilities Act, and in particular, this website litigation that has been going on around the ADA. And of course, as you can see from the slide, he has a broad practice in and around labor and employment with the firm. Today, Jordan's going to be speaking to us, though, about website litigation under the ADA. Protect your property from lawsuits. Jordan, always good to have you back. Take it away.
Great. Thank you very much, Steve. And while I wish we could all be together in person, hopefully next year we'll be able to do so. But for now, virtual is certainly better than nothing. And in a way, it's a little bit appropriate for my presentation here, which is dealing with virtual/website litigation. And, surprisingly, because everyone is staying home more so than in the past, these website litigation claims are continuing to rise. Whereas the claims of plaintiffs going on properties, either restaurants or hotels, is not currently rising. It's not necessarily on the decline. I've still seen some lawsuits, but the website cases are continuing to take off. So let me just jump right in. Let's go to the first slide here so I can just kind of, give you a quick overview of what you need to be aware of to really save your company, your restaurant, your hotel, your any place of public accommodation, save you the headache, the expense, and really just the general unpleasantness of getting sued under Title III of the ADA. Just real quickly, Title III of the ADA applies to every place of public accommodation, whether that's a restaurant, a resort, any sort of spa, any sort of amusement park, and certainly hotels as well. And it prohibits all it says on the second bullet point here, hotels, but in reality, it prohibits all places of public accommodation from denying services and accommodations to individuals with disabilities. Now, 6, 7, 8 years ago, everyone thought that only applied to the actual physical structure, the actual restaurant, the actual hotel. That is not the case anymore. As a result, you as a company, you must modify your policies, practices, and procedures. And the reason I put that is the language in the regulations, but that applies to websites. And additionally, you must remove your barriers to access for individuals with disabilities on your websites, so that someone with a disability cannot sue you based on an inaccessible website. And let's move right to the next page so I can explain to you, what does an inaccessible website mean? And there are basically two factors, and they are not related. If I have a phone call from someone that says, Jordan, I need you to represent me based on a website accessibility case, I will not know until I ask them more questions if they're talking about number 1 or number 2. So for the next 7 or 8 minutes of this presentation, I'm going to split it first between talking about number 1, does your website need to be accessible for users with visual, hearing, and physical impairments? That is number 1, and that is separate from then the second question, which is, does your website need to provide information regarding accessibility features at your hotel? And number 2 is limited to hotels and resorts and inns, all places of public accommodation. Number 1, it applies to all places of public accommodation. So let's go right to the next slide and get in more detail about number 1, which applies to every single person on this call. Must my website be accessible for those who are hard of hearing and seeing? And my answer has changed over the past couple of years, and now it is essentially a definitive yes. The actual regulations still don't talk about websites. Eventually, they will be added into the regulations. Right now, they do not discuss websites. And in the beginning, 2015, 2016, 2017, courts weren't so sure. Are websites places of a public accommodation? Some said most likely, some said maybe, some said, we're not sure. However, in the past few years, and I'll get to a case in a minute, I have this third bullet point, the trend, and it's not only the trend, it is almost unanimous at this point that courts find that websites are places of public accommodation, and as a result, they must be accessible for individuals with disabilities, which means they must comply with something called the Web Content Accessibility Guidelines. We're up to 2.1. It used to be 2.0, and now it's 2.1. And I'm not going to get into detail about what those mean, but what you will need to do, hopefully after this presentation, is sit down with some of your techies and the people who design your websites to try and figure out if your website is compatible with the WCAG standards. Now, if you go to the next page, as I mentioned, I'm just going to talk about one case now. Yeah, I'm not gonna, we lawyers love to talk about case law, and I have a bunch of cases that I could talk about, but this just kind of gives the whole history of what's happened. An individual tried to order a pizza from Domino's, and he couldn't because Domino's website was not compatible with screen reader software. And when this case began in 2017, a California court said, you know what? There's no regulations that specifically say the website must be accessible. So we're going to rule for Domino's and say they didn't have due process. There was no law that they had to make their website accessible. The Ninth Circuit, which is the Court of Appeals, the second highest court in the land, reversed the decision and said Title III of the ADA does apply to websites. And the fact that there are no regulations is irrelevant. There's case law. Domino's knew or should have known that they should comply with WCAG, and as a result, they are required to do so. Domino's then petitioned to the US Supreme Court, and the Supreme Court said, you know what, we're not even going to hear this case. So for the most part, while it is not quite the same as having a Supreme Court decision, the law, at least in the Ninth Circuit and in every other circuit that has ruled on this issue, is that your website needs to be compatible with screen reader software. It is possible another company like Domino's could challenge and could spend hundreds of thousands of dollars in litigation and possibly win. And maybe a higher court will agree with the California lower court in March of 2017. It is extremely unlikely, though, and probably not worth the cost that would be attached to that to try to get such a favorable result. So moving on, given that that is the law, practically, what does this mean? That means that you need to be extremely careful of your menus that are in PDF formats. Those menus likely aren't compatible with screen reader software. You need to be careful of, on your website, if you have pictures, maps, diagrams with no written descriptions. Same with links with no descriptions. Audio and video files with no captioning. You also someone needs to be able to use a mouse. You can't just require a keyboard without a mouse. So those are the things you'll have to work with potentially an accessibility consultant to determine whether or not your website has these features. Moving on to the next slide, that is something I strongly suggest is retaining an accessibility consultant so they can review your website to see, is your website compatible with screen reader software or is it not? And if it's not, then you can decide what to do to fix it, remediate it so you do not get sued. And I'd also caution you to please use legal counsel while you retain an accessibility consultant. So anything, the guidelines that the accessibility consultant provides can be protected by attorney-client privilege. Now, moving on to the next slide, one other quick thing I want to mention before we get to the second part of this presentation is all of your websites should have an accessibility statement on it. What that says is we are doing our best to try to make our website and our products accessible. Essentially, there's a little bit more than that. I can help, or someone similar to me can help you guide, with your basically a paragraph, and then you end it saying, here is someone you can speak to if you have accessibility concerns. If someone is about to bring a lawsuit, they will look to see if you have an accessibility statement. And while an accessibility statement doesn't shield you from all liability, it does strongly help and prevent a plaintiff from potentially bringing a lawsuit. Now, moving on to the next slide, we have the second part of the website accessibility issues, which this relates to hotels and it relates to your property being accessible, but your website needs to explain how your property is accessible. Your website also needs to allow an individual with a disability to reserve an accessible room on your website. It cannot say, for an accessible room, please call the website, or I'm sorry, please call the property. You need, someone needs to be able to reserve it online, assuming someone can reserve a non-accessible room online. It just needs to be reserved in the same way. Moving on to the next slide. And actually, I'm gonna skip the next slide and go to, let's go to the next slide after that. You want also, individuals need to be able to reserve, once an individual with an accessible room is reserved, once an accessible room is reserved, that needs to be blocked from the system. I'm seeing too many lawsuits where an individual, let's say, reserves a room with a roll-in shower. Then the individual gets to the property, asks for his reservation, and they say, oh, sorry, we gave away that room, but we have a different room. That doesn't help. There's going to be a lawsuit because that individual specifically booked a roll-in shower because that is what they wanted, and a tub with a seat doesn't necessarily meet this individual's needs. So make sure specific accessible guest rooms on websites are blocked out and reserved, blocked out once they are reserved. And now to the next slide, the most important part of this second website issue is that your website must identify accessible features in your property. And that is just working with someone like me. You don't need to hire an accessibility consultant. You don't need a techie. You just need someone who can sit with you for an hour and talk about the accessible features of your property and just add a bullet point list to your website. That will save you tens of thousands of dollars from lawsuits. I am defending 4 or 5 small properties right now, not huge major corporations, small properties that a plaintiff just is plaintiffs are looking at every single property online right now and seeing which properties don't have a bullet point list of accessibility features, and they are suing. So this is an easy fix, and I urge everyone on this call, on this presentation here, to make sure you have these features of your property described on your website. And going to the next slide, all that means is, provide information about popular common areas, a restroom in your entrance, in your lobby, your entrance, your registration check-in, the route to the restroom, things of that nature. And just make sure to provide accurate information. You don't want to say you have an accessible entrance if you don't, because then if the individual comes to your property, you're going to get sued, for that violation. And moving on to what I believe is the final slide, you also need to provide information about the accessibility of your accessible guest rooms. And all that means is you want to say if it's a double-double or a queen or a king, if it's a roll-in shower or if it's a tub. That is all you need to provide, but you need to provide that information. You can't just say accessible bathroom, because then someone who has particular needs cannot actually make the reservation that suits those needs. And then, as I said, once you provide that information, there needs to be a mechanism so that an individual can actually book that room online. And moving on to the next slide, I believe that is all the slides, but this is my blog. We write about this all the time. If you ever want to go to the employerdefensereport.com and just read about these types of issues, you can sign up for free, and I write an article about once a week or so. But just to sum up the 3 takeaways from this presentation is add an accessibility statement. Every person on this call, restaurant, hotel, spa owner, whatever you are, just add a paragraph accessibility statement saying that you take accessibility seriously and asking if you have any questions. 2, have some sort of accessibility consultant review your website to see if it's compatible with screen reader software. And 3, for the hotels on this call, make sure there is a link somewhere on your page, on your homepage, that someone can click on, an accessibility link, either on the top or on the bottom, that takes you to a page where you can provide bullet point information about the mobility accessible features at your property. And with that, I will sign off. I will be available for a further deep dive discussion to discuss these issues in further detail and hopefully answer any questions you might have. Thank you very much.
Thanks, Jordan. That's terrific information as usual and very helpful. Everybody, you'll want to join Jordan for his deeper dive discussion in this litigious area. Jordan, thanks again for joining us. We'll look forward to visiting with you at your deeper dive.